afternoon. Welcome to our meeting, which begins the study on SEPA enforcement. Before we start, I would just like to read out the second report from the Subcommittee on Agenda and Procedure of our committee, and have the committee adopt it because it essentially lays the groundwork for today's meeting. So your subcommittee met on Thursday, December 3rd, 2020 to consider the business of the committee and agreed to make the following recommendations: that for its meeting of Wednesday, December 9th, 2020, in relation to the enforcement of the Canadian Environmental Protection Act study, the committee invite Mr. Amir Attaran from the University of Ottawa, Mr. Muhannad Malas from Environmental Defence, and a third witness at the discretion of the chair. So we have today with us three witnesses. I'm told Mr. Attaran was not able to make it, he's away, but we have David Wright, retired Crown Prosecutor in Ontario. We have Muhannad Malas, or Malas, I'm sorry if I'm not pronouncing it properly, Program Manager Toxics with Environmental Defence Canada, and Ben Sharp, Senior Researcher and Canada Lead at the International Council on Clean Transportation. Alors, comme d'habitude, vous pouvez
As usual, you may speak in the official language of your choice. When you are not addressing the committee, would you be so kind as to mute yourselves? Without any further ado, I would now ask...
Have we not ratified the subcommittee reports so we can have the hearings today?
Yeah, sure. I sense that there's consensus,
If
but
so, I'll move it.
Okay, yeah, my mistake. I apologize for that.
Maybe just unanimous consent. I'm sure we'll get it.
Yeah, is there unanimous consent? Seeing no objections, the second report is adopted. Thank you, Mr. Albas. So we'll start with Mr. Wright for 5 minutes, please. Mr. Wright?
I hope you can hear me.
Yeah, we can, yes.
Good. Good afternoon, Honorable Chair and committee members. My name is David Wright, a recently retired Assistant Crown Attorney employed with the Ministry of the Attorney General for 32 years. I am currently litigating for Eco Justice, an environmental organization based in Vancouver. On March 10th, 2017, in Detroit, Michigan, Volkswagen pleaded guilty to 3 criminal felony accounts and was fined $2.8 billion for cheating on emission tests mandated by the U.S. Environmental Protection Agency in regards to 590,000 diesel-engined vehicles, a fine of $4,745 per vehicle. On January 22nd, 2020, Volkswagen pled guilty to violations under the Canadian Environmental Protection Act and was fined $196.5 million related to the installation of illegal emission software in 128,000 vehicles. This is, equals a fine of $1,535 per vehicle. And Volkswagen received special procedural treatment in court. Let me explain briefly what normally happens when federal charges are laid. I'd like to note that the criminal code rules apply to environmental prosecutions. Once a charge is laid, the accused attends court for a first appearance, normally within 3 to 4 weeks, allowing time to prepare the Crown to prepare for disclosure. On this first appearance, disclosure is then provided to the defense lawyer. Next step is the formal meeting between the Crown and defense, called a Crown pretrial. In serious cases, a judicial pretrial, JPT, must be held. This is a meeting between a judge, Crown, and defense to determine if the case can be resolved or whether the trial issues can be narrowed to save court time. The case is then either resolved or a trial date is set. If a case is resolved, the victim will be advised before the plea proceeds. Resolution for these types of offenses normally takes between 3 and 5 months. What happened with Volkswagen? 60 charges under the Canadian Environmental Protection Act were laid December 9th, 2019. The first appearance was December 13, 2019, in other words, 5 days ahead. The agreement between the Crown and the defense was for Volkswagen to enter a guilty plea and be sentenced on that same day, as acknowledged in the court transcript of December 19th, 2019. Differing from any usual prosecution, Volkswagen did not have to repeatedly attend court, publicly obtain disclosure, publicly set a Crown pretrial, and publicly set a judicial pretrial, like every other accused in Canada. There is nothing on the court record or information to show that Volkswagen ever received disclosure. There's nothing on the record to show that Volkswagen ever attended a JPT. As required, the court record or information would record these events to maintain an official accounting of all that happens once a charge is laid. It is inconceivable that Volkswagen pled guilty and agreed to a $196 million fine without receiving disclosure. With just 5 days between the laying of the charge and the scheduling of the plea, the only explanation is that Volkswagen received disclosure before the charges were laid December 9th, and this is a major breach in protocol. The reason this is significant is that prior to December 9th, the Crown still had the discretion to determine which charges, if any, should proceed. To be clear, it was in the Crown's discretion to lay criminal code conspiracy charges against Volkswagen, as was done in the United States, not the less serious charges found in the Canadian Environmental Protection Act. It is also inconceivable that a plea went ahead without any pre-trials. While there is no written court record of either Crown or pretrial or judicial pretrials taking place, both had to have occurred as it would be negligent on both parties not to hold these meetings. Given the timing, the judicial pretrial may have occurred before the charges were laid. The 60-count plea was scheduled for December 13th. However, the plea stalled when Echo Justice asked the victims to be allowed to provide a community impact statement pursuant to Section 722.2 of the Criminal Code. The case adjourned to January 22nd, 2020 for submission of the impact statements, the plea, and sentence. And what is a community impact statement? Even though Environment Canada had been locked in litigation with Echo Justice for years regarding Volkswagen's unlawful conduct, it told no interested parties at the date the charges were laid or that a plea was pending December 13th, 2019. No environmental or health organization had time to prepare any type of response, including a community impact statement. On January 22nd, 2020, contrary to the mandatory provisions of the Criminal Code, the Crown unilaterally disallowed community impact statements presented by Echo Justice, saying it was, in quotes, untested, end quotes.
Thank you, Mr. Wright. We're a bit over time, but there's a lot of material in your presentation for the questions. I'm sure your presentation will elicit many questions. Before we go on to the second witness, I would just like to mention to members that at around 5:15 or so, I'm going to ask the committee to go in camera to consider the third report from the steering committee regarding the work outline for the report on zero-emission vehicles. Mr. Malas, 5 minutes, please.
Good afternoon. Thank you, Mr. Chair, for the invitation to speak to you about this important matter today. My name is Mohanad Malas, and I'm the Toxics Program Manager at Environmental Defense. Environmental Defense is a leading Canadian environmental advocacy organization that has for over 30 years worked with government, industry, and communities to safeguard our fresh water, decrease Canadians' exposures to toxic chemicals, and build a clean economy. Environmental laws are only as effective as their enforcement. In the case of the Canadian Environmental Protection Act, or CEPA, proper enforcement means holding accountable polluters who put the health of Canadians and their environment in harm's way. In 2015, Volkswagen was caught installing a cheat device in more than 11 million diesel cars worldwide. That device lowered emissions when the vehicle was operating in test mode, but once on the road, they emitted up to 35 to 40 times the permitted levels of harmful nitrogen oxides. a pollutant associated with many deaths according to Health Canada, as well as cancer and other illnesses. In Canada, 128,000 of these rigged vehicles were imported and sold during a period of 7 years. For what is arguably one of the worst environmental crimes ever committed in Canada, the government's enforcement by any reasonable measure was hesitant, weak, and inadequate. After launching its investigation in September 2015, it took more than 4 years for the federal government to charge and prosecute the company. This is despite a guilty plea agreement between Volkswagen with the US federal authorities in January 2017 that precluded the company from retracting its admission of guilt in other jurisdictions. And this is also despite testing done in Canadian government labs in Ottawa being used as evidence by the US government. Troubled by the lack of public progress made by the government, in July 2017, so just less than 2 years after the investigation launched, I submitted a CEPA Section 17 request to the Minister of Environment and Climate Change to open a transparent investigation of Volkswagen's violations. Citing the government's ongoing investigation, the minister refused to investigate 3 of the violations I outlined in my request, including the import and sale of rigged vehicles. This essentially meant that the government was able to continue its investigation without the obligation to provide progress updates. For the investigation that the minister agreed to open, which covered the continued sale of 2015 model cars that received a half fix, I received 12 progress update reports over the following 3 years that offered little to no meaningful information about the government's progress. In the end, after more than 4 years, Canada reached a plea deal with Volkswagen that appeared to be pre-negotiated prior to any charges being laid and fined the company $196.5 million. While this is the largest fine ever levied in Canada, the amount pales in comparison to what the company paid in the US and could have been much higher had the charges not been packaged in a way to reduce the maximum penalty. By contrast, the US charged, prosecuted, and fined Volkswagen more than $10 billion within 20 months. In our view, the federal government's failure to provide updates about its progress within the 4 years plus of its investigation reflects a failure to respect the spirit and intent of CEPA and the public participation rights it grants Canadians. The Volkswagen investigation underscored a number of glaring problems in the enforcement of CEPA that were highlighted in this committee's 2017 review of the Act. One key problem, for example, is that CEPA's citizen enforcement provisions, which allow concerned citizens to bring an environmental protection action, or an EPA, against a person or company that has committed an offense, are overly onerous and ridden with barriers that are effectively insurmountable. For example, in order for a citizen to bring an EPA, they must first request an investigation by the minister and then demonstrate that the minister failed to conduct the investigation or that their response was unreasonable. Additionally, a concerned citizen must demonstrate that a violation is responsible for significant harm to the environment and run the risk of having to pay substantial cost awards if they are unsuccessful. As a result of these barriers, no citizen suits have been commenced or completed since the enactment of CEPA in 1999. As the government proceeds with developing a bill to modernize CEPA as promised in the government speech from the throne, we urge Parliament to adopt the committee's 2017 recommendations to strengthen CEPA in a manner that removes these barriers and improves public participation in the enforcement of the Act. Thank you very much for your time, and I look forward to your questions.
Merci, Monsieur Malice.
Thank you, Mr. Malice, and now to Mr. Sharp for 5 minutes.
Monsieur Sharp.
Mr. Sharp.
Very much, Mr. Chairman. To the Standing Committee on Environment and Sustainable Development, good afternoon, and thank you very much for the opportunity to provide remarks regarding charges brought against Volkswagen in December 2019 under the Canadian Environmental Protection Act. My name is Ben Sharp, and I am a senior researcher and Canada lead for the International Council on Clean Transportation. We are a research organization that is focused on providing technical information to support government decision-making on policies for leading vehicle markets around the world. Today, I'll make comments regarding the essential elements of a robust vehicle emissions regulatory program and the breakdowns that led to the Dieselgate scandal. Then, I'll highlight the large discrepancy in the Volkswagen penalties in Canada as compared to the United States and how this represents a significant detriment to Canada. Finally, I'll summarize some of the ways in which Dieselgate has fundamentally altered the course of the global auto sector and has been a significant contributing factor in the accelerated transition to vehicle electrification. A strong vehicle emissions regulatory program requires that vehicles are tested under a wide range of operating conditions, and there are specific protections against cheating. So how did Volkswagen and so many other manufacturers cheat the system? Well, simply put, they designed vehicles that tricked regulators by performing well in the laboratory and meeting all of their required emissions levels. But as soon as these vehicles sensed that they were in actual real-world driving conditions, their control algorithms drastically ratcheted up nitrogen oxide, or NOx, emission levels so that the vehicles would get better fuel economy. These so-called defeat devices were at the heart of the Dieselgate scandal. Since we first uncovered the defeat device issue in 2014, the ICCT has been at the forefront of research and policy analysis to identify the full extent of the cheating issue and present concrete solutions to policymakers to strengthen vehicle regulations and improve real-world emissions performance. The ICCT has developed step-by-step guidance for helping regulators to identify vehicles with defeat devices, which can be challenging since the devices are embedded with sophisticated computer code. The ICCT is the world's leading research organization with regards to vehicle compliance and enforcement and real-world emissions evaluation. As an addendum to my testimony, I've included a list of roughly 30 papers, consultant reports, and blog posts that we have published on these topic areas. In addition to designing vehicle emission regulations to explicitly close software algorithm loopholes, it's equally important to have sufficient enforcement provisions and penalties in place to deter manufacturer malfeasance. The discrepancy between the fines collected from Volkswagen by the US and Canada are significant and deserve further scrutiny, which is why we applaud the committee for taking up this investigation. Altogether, Volkswagen's fines and penalties in the US total roughly 32 billion Canadian dollars as compared to 196 Canadian dollars in Canada. With roughly 580,000 and 128,000 guilty vehicles sold in the US and Canada, respectively, this works out to about $55,000 per vehicle in the US versus $1,500 per vehicle in Canada. More transparency is needed to determine how Canada came to a settlement that has resulted in significantly lower penalties on a per vehicle basis versus the US. In response to the Dieselgate fallout over the past 5 years, diesels are now much less attractive to both consumers as well as manufacturers. For example, in Europe, diesel market share has fallen over 40% since 2015. Given the additional cost associated with re-engineering diesel vehicles to comply with increasingly stringent emissions requirements, several manufacturers have divested from diesel technology and have instead made aggressive pivots towards electrification. Not coincidentally, Volkswagen is leading this rapid transition to electric drive and announced in 2016 that electric vehicles will make up 25% of their annual sales globally by 2025. Another way in which Dieselgate has turbocharged the transition to electrification is that a significant portion of the Volkswagen settlement funds, nearly $3 billion US dollars, are specifically earmarked to support US states with programs that accelerate electric vehicle development. In summary, Dieselgate has illuminated the critical importance of having well-designed regulations, as well as robust compliance, enforcement, and penalty provisions to ensure that emission reductions are achieved in the real world and not just the laboratory. While the Canadian government's action against Volkswagen represents the largest environmental fine in the country's history, this committee is very well justified to probe the manner in which the settlement was reached. Thank you very much for the opportunity.
Merci, Monsieur Sharp. Votre témoignage touche un peu.
Thank you very much, Mr. Sharp. Your testimony, in fact, is related to the study we've just completed, so I'd like to congratulate the committee for organizing these topics in this sequence with such connections to each other. And now we're moving into the 6-minute question round, beginning with Mr. Abbas.
Chair, and I'd just like to thank our witnesses for taking the time to be here to discuss this important issue with us today. I'm just going to ask a general question of each witness. Maybe we'll go from Mr. Wright to Mr. Melas to Mr. Sharp. I'd like to have a fairly succinct answer with just maybe a little bit of follow-up. Do the witnesses here today believe that the penalties were commensurate with the crime? And if not, was that the fault of the way the law is currently structured, or how the government executed this? So if we could go to Mr. Wright, could you start with that?
I haven't looked closely at the environmental legislation with this issue in mind. So I don't think I could properly advise the committee with respect to this question.
Thank you. Mr. Melas?
Thank you for the question. From our perspective, the perspective of environmental defense, I think, as I outlined in my statement, there are a number of gaps within the legislation, SEPA, that have enabled the investigation to proceed in the way that it did. And these issues were highlighted and underscored in the review by the ENVI committee in 2017, and that resulted in a number of recommendations on how the enforcement provisions could be improved. So from our perspective, the legislative framework is a key problem. And the fact that we weren't able to get much information from the government when the investigation was happening, which was due to the fact that the legislation did not compel the government to provide that information to us. I'm not able to answer about, or answer to the I guess second part of the question about, whether there was other factors in play because I don't have the information at hand.
Thank you. Mr. Sharp?
Yes, thank you for the question. I will certainly defer to Mr. Wright and Mr. Melas in terms of the legal procedure and legislative structure of the Canadian Environmental Protection Act. From the ICCT's perspective, looking at the penalties that were determined in the US and California, looking at the magnitude of the fines that were levied for Canada, it's certainly a very large discrepancy, and at least to us, points to a breakdown in the procedural way in which these fines were determined. And from Mr. Wright and Mr. Melas, it seems like there has been a lack of transparency throughout the process.
Thank you. So I think I'll go back to Mr. Melas because you do seem to have a lot of track on exactly how these investigations are done. So the info we received from our analyst shows that the SEPA investigations totaled 4,915 in the final year of the last Conservative government. And since then, it's declined every single year during the current, while the current government's in power. I think last year it was only around 1,600. So why do you think that these investigations have declined so considerably in the last few years?
Thank you for the question. I think to answer this question, I would point to a number of reports that were published by the Auditor General's Office, by the Commissioner on the Environment and Sustainable Development, which highlighted in a number of instances, I believe there were 3 reports that so far looked into enforcement: a 2009 report, 2011 report, and 2018 report. And some of the findings have been consistent in terms of the way Environment Canada and Environment and Climate Change Canada has invested resources and capacity in enforcing its regulations. So the last report that came out in 2018 showed that I believe over 2,000 of the 10,000 inspections and enforcement actions conducted by the department, just to paraphrase, 2,000 out of the 10,000 inspections and enforcement actions conducted by the department were targeting dry cleaning businesses. These are, mostly small to medium-sized businesses, and the audit showed that there was no prioritization of risk in terms of, how the department allocated its resources. Many very important regulations, like the prohibition of toxic substances regulations that prohibit 26 substances, did not receive one inspection in 2018. But once again, I just wanted to emphasize that some of these findings have been consistent throughout the audits that were done by the environmental commissioner. And there's also an issue of resources and funding, which we believe, and we have provided recommendations over the years in terms of increasing the funding going towards the enforcement department within ECCC.
You have time for a comment, Mr. Alves?
Yeah, thank you. I'm glad you raised the Auditor General and the Environmental Commissioner. Do you believe that the government is adequately funding these areas? It seems to be something you've referenced a few times.
I don't believe the government is funding these areas and enforcement actions adequately.
Okay, thank you. We'll go to Mr. Shifke for 6 minutes.
Thank you very much, Mr. Chair. And I'd like to also add my thanks to all of our witnesses for being here today and for their work in helping protect Canadians from environmental challenges and issues that may be consequential to them. The first question that I had, and this is, kind of a broad study on how we can improve upon enforcement mechanisms within SEPA and give more powers to the government to be able to better protect Canadians. And, given that we haven't had a briefing by officials yet on the full scope of enforcement operations, I guess I'll kind of go more broad. And my first question would be for Mr. Sharp. We know that countries around the world have a wide range of enforcement regimes to ensure the safety of their populations. And I'm wondering, based on your experience and what you've come across, could you point to a few examples of success stories across the world where innovative enforcement practices led to greater protection against harmful substances, for example, or greater protections to the population in general?
That's an excellent question. So this has become a huge part of our focus as an organization since 2014 and 2015, when all of these revelations started to come to the fore. We've been working very closely, primarily with regulators in the European Union. As you may know, defeat devices, the definition and use of defeat devices has not been illegal in the European Union. So one of the biggest efforts that we've put in over the past few years is to ensure that these devices cannot be used in that jurisdiction. In terms of some innovative ways to catch vehicles that may be cheating, we've developed several methods, including remote sensing. And we have, several documents that I've shared with the committee that provide additional details as to how those methods can be employed. We're very excited to see many of the governments that we work with start to use these remote sensing methodologies to be able to test a very large number of vehicles very cost effectively. In the past, it was very expensive to gather data from vehicles in the real world, given the need to put expensive equipment on the vehicles. That's no longer the case when doing remote sensing. So we, as an organization, are very optimistic that remote sensing is going to be the primary method by which governments can collect a very large amount of vehicle real-world emissions data, and then link that to actual compliance and enforcement regimes.
Thank you for that, Mr. Sharp. The next question I have is one relating to chemicals management, which is a big part of SEPA and the chemicals management plan. And the question I'll put to Mr. Malice. So Canada's committed to implementing the 2030 Agenda and its Sustainable Development Goals, the SDGs, and 12 of them aim to ensure sustainable consumption and production patterns. Target 12.4 is to, by 2020, achieve the environmentally sound management of chemicals and all wastes throughout their life cycle in accordance with agreed international frameworks, and significantly reduce their release to air, water, and soil in order to minimize their adverse impacts on human health, the environment. And the question I have is, what role would you say SEPA has in getting us closer to achieving 12.4, and how can we do a better job at it? What can we do within SEPA to achieve that?
Thank you for the question. I think SEPA is the most critical legislative tool that we have to achieve that target. And I think the opportunity that we have today with modernizing SEPA can really bring us, you know, forward in terms of achieving not only those global targets, but also our domestic targets. So one of the issues that we've had in our chemicals management plan has been the fact that we have not, and this is again, has been shown by the Auditor General report over the years, I guess, that we have not measured performance. We have not seen if our chemicals management has actually led to meaningful reductions in exposures and meaningful reductions in risk to the environment. And when it comes to some of the major issues and gaps that we have within SEPA, when it comes to chemicals management, it's the fact that we do not require our risk assessment regimes and our risk management and regulatory regimes to consider vulnerable populations and marginalized communities who are most disproportionately affected by toxic substances. So some of the vulnerable populations could include biologically or physiologically vulnerable communities, whether it's pregnant women and children, or you know, socioeconomically marginalized communities. So, and if we don't address those communities and provide them with the protections, you know, adequately, then we're not really going to be able to meet those targets domestically and globally, as I said.
If you have time for a comment, Mr. Shifke.
Thank you, Mr. Chair. So, Mr. Malice, you'd be fully supportive of the implementation of the the aspects of the 87 recommendations that deal specifically with those areas that you see as gaps that need to be filled.
I would strongly support those recommendations by the ENVI committee in 2017. We see them as a blueprint for how SEPA could be modernized and become, you know, be brought to the 21st century, because we still have a legislation from 1999.
Okay.
Thank you, Mr. Malice.
Madame Posé pour 6 minutes.
Oui, thank you, Madame Posé, 6 minutes. Thank you. I'm going to piggyback on what Mr. Shifke was just talking about. So I would like to address Mr. Malice again. Among the 87 recommendations, which were the most pressing problems in your mind regarding these recommendations and the enforcement of the Canadian legislation? If I were to say which were the top 3, what would you say the most urgent, you know, given the climate emergency?
It's a tough task to reduce 87 recommendations to 3, but I can definitely take on the challenge. I would say the first top priority would be to ensure that vulnerable populations and marginalized and racialized communities, and especially Indigenous communities, are adequately protected from toxic substances and pollution. So those recommendations that pertain to vulnerable populations are critical. And very related to that is recognizing Canadians' right to a healthy environment within SEPA, which would be the first time that a federal legislation would have a recognition of that right, and those two go in hand. You know, protecting vulnerable populations and recognizing the right to a healthy environment are really two sides of the same coin. And then the other recommendation I would say is around how we risk assess chemicals. We have a one chemical at a time kind of approach, and we have tens of thousands of chemicals on the market. We need to be smarter. We need to go where the best practices are globally in terms of looking at classes of chemicals, cumulative effects, and ensuring that we're addressing, you know, exposures in a holistic way as opposed to in an individualistic way. And the third one would be around enforcement. And I would just highlight a couple of things that I mentioned in my statement, which is to ensure that we have civil enforcement mechanisms that enable the public to participate in decision-making and enforcement.
Merci beaucoup, Monsieur Malas. Vous me rejoignez beaucoup quand on...
Thank you very much, Mr. Mellis. I agree with you, and you were saying things that I fully agree with in terms of human health and toxic substances. I have another question for Mr. Sharf. I'd like to congratulate you, first of all, for your interventions in the electric mobility convention, and I learned a lot from listening to you. Towards the end of 2007, your organization published a report on monitoring and enforcement of vehicle emissions in 14 markets, and you see that Canada did not do very well. Since early in the Volkswagen investigation, what did Canada do to improve its monitoring and enforcement activities?
Rapidement, j'ai un autre...
Briefly, please, because I have another question to ask after this one.
Sure. I don't know specifically what actions Canada has taken that would have been different than the United States. As you well know, the Canadian and US federal regulations are very much tied and aligned and intentionally harmonized given the alignment across the markets. So I do not know of any specific actions Canada has taken over and above in terms of its compliance and enforcement actions.
Bon, je vous remercie. Je vais revenir.
Thank you. I'd like to get back to environmental redress. In the United States, you were mentioning that the fact that Volkswagen had been opposed to anything that could have protected the environment, they had to pay. So there was a question of reparations, and they had to work on zero-emission vehicles. So that was the link to our previous motion. So for you, with your international vision, with your organization, do you think that this is something that is going to occur in all countries? In other words, having this notion of making reparations when there are fines?
From the ICCT perspective, we believe that mobilizing these penalty funds to move towards electric drive is a best case scenario. Certainly, electric vehicles of all types, both light and heavy duty, there's going to need to be a lot of policy support, a lot of sustained long-term funding in order to jumpstart this transition. So it really is, at least from our perspective, a win-win. You certainly want to penalize malfeasance and cheating. That's pivotal as a deterrent. But to be able to put those funds towards something that is really critical in terms of protecting the climate, we really think that it's just something that Canada, it's a really big lost opportunity in our minds. One of the things that we've been looking at quite a bit over the past 2 years is Canada's role in the electric vehicle transition. It's falling behind some of the other auto producing countries, at least currently. And so Canada needs to be doing all it can to make up some lost ground in terms of auto producing and particularly electric vehicle production. So we think that,
Mais plus particulièrement sur
more specifically, about the redress, the penalty funds. Volkswagen paid a fine, but there was a $2 billion zero-emission technology fund. So it wasn't just paying a fine, but this concept of making reparations. Is this something that's envisageable? Could you, yes or no, just quickly? Unfortunately, we really don't have any more time, but I will allow you to say either yes or no.
Yes.
Parfait, c'est bien. OK.
Excellent.
Hi there. I want to echo the thanks to our witnesses today. Thanks so much for being here. My first couple of questions are for Mr. Wright. And it was mentioned that in the US, there was only a year and a couple months between when the EPA issued a notice of violation to Volkswagen and when the company that pled guilty to the criminal felonies and agreed to pay billions of US dollars. In Canada, the ECCC began investigating charges, and then charges were only laid 4 years later. And so I'm just wondering, Mr. Wright, as part of their plea agreement in the US, Volkswagen entered an agreed statement of facts in 2017 that would be legally admissible in Canadian court. Shouldn't that have meant that the investigation would be easier or quicker here in Canada?
Yes, it would have been much easier. The Canada Evidence Act, Section 23, allows for foreign judgments and foreign findings to be applied in Canadian courts, and it certainly would have streamlined and assisted any prosecution. The fact that it took another almost 3 years for the case to get brought before a court and for it to be resolved is unexplained at this point. Why did it take so long? The Canadian standards are based on the American standards. So in essence, you're dealing with exactly the same case, you're dealing with exactly the same evidence, you're dealing with the same victims, you're dealing with the same people who uncovered the problem in the United States. So my view is that when you have, in essence, the same company, it's a different corporate entity, but it certainly would be of great assistance to any prosecution. It doesn't mean that the prosecution would be there'd be no paper involved. There'd be lots of paper involved, but the prosecution would be much more, or should have been much more streamlined.
Do you have any idea why it would have taken 4 years? And can you explain how the legal process in the case like this usually works? Is it, and it, you know, I think you mentioned kind of it might have been unusual that charges were negotiated before they were laid?
In my experience, it's extremely unusual that disclosure would be given prior to the charges being laid. It implies that there are discussions taking place between defense, not the accused, not the investigators, but the defense counsel as to next steps and how the matter is to be dealt with. That's extremely unusual. And it's not open. It's not what we should be doing. Justice should be seen to be done. It must be clear and transparent, and the public should have an understanding that these cases are progressing through the courts. There should be pronouncements at various points as to the progress of the prosecution. That didn't happen. In fact, the involved organizations did not have a chance to make input regarding the ultimate resolution of these cases, this case.
And Mr. Wright, just a question, are there any other cases that you're aware of where charges would have been negotiated before they were laid in this way?
I'm not aware of any charges that I've in 32 years, I've never seen anything like this.
Thank you so much. And in the US, Volkswagen faced criminal charges. Would criminal charges have been possible here in Canada?
I think so. I think that conspiracy to commit an indictable offense, fraud, are two criminal charges that could well have been laid. The Crown could have taken that option, and I didn't really see where the loss would be to commence with criminal charges and then at a later date looking at complexities that arise or enormous amounts of time or disclosure problems or any of those things. You can always have the fallback of the indictable offense that's found in the Canadian Environmental Protection Act. So the use of the criminal code should be done when you're dealing with extremely serious environmental crimes, such as the one that was presented to the Canadian public by Volkswagen's actions.
And maybe just opening this up to Mr. Wright or Mr. Malice in terms of just any ideas why it would have taken 4 years and any changes to the current legislation, SEPA, et cetera, that would allow us to use or go towards criminal charges in these kind of cases.
I just think from my perspective, the Crown in making the assessments as to how best serve the public should certainly consider criminal charges when the kind of flagrant violation has occurred. It's every tool should be looked at, and every tool should be looked at carefully. And we have no evidence and no report. The public doesn't know. So my thought is that the process should be much more transparent. That the Crown and the investigators should be working hand in hand with organizations and the public to ensure that these cases are properly dealt with.
Our time is essentially up. We'll go
I'll
now
follow
to
up in the next round.
we'll go to the second round now, but I'm not sure who's asking on behalf of the Conservatives.
I will, Your Worship, or
Mr.
Mr.
Albus?
Chair, I will.
Okay, go ahead
Pardon me.
for 5 minutes. Yeah.
Yes, thank you. So I would like to ask, is there any evidence that suggests that individuals who file complaints with authorities are not having their complaints investigated? And I should say, Mr. Chair, this is directed again at Mr. Mellis.
Sorry, could you repeat the question? Is there evidence?
Is there any evidence that suggests that individuals who file complaints with authorities are not having their complaints investigated? You mentioned your own case.
Yeah, so in my case, after about 2 years, I think it was 22 months exactly since the investigation was launched, and we were worried about nothing happening from that investigation, given that no public updates were provided in that period, and I believe there's a statute limitation in SEPA in terms of it's a 2-year limit, and if somebody doesn't bring an Environmental Protection Act action as a citizen within the first 2 years of an offense, then they can't do it afterwards. So that's why I filed that request under Section 17 for the minister to launch an investigation. And we were troubled that out of the 4 violations that I outlined in my request, 3 which were critical: the sale, the import, the sale, and of those cars, and also misleading and lying to the government and to the regulator. So those 3 violations, are absolutely essential in terms of what happened with VW. The minister refused to launch an investigation, citing the ongoing investigation as a reason, and that basically kept the public in the dark about what was happening. And then in terms of as I said, and not to repeat myself, but just to highlight an important point, the investigation that the minister did open based on my request, which was the continued sale of 2015 half-fixed vehicles, for almost 3 years, I received 12 progress update reports, and there was no information in those update reports about the status of the investigation. The report often, just told me that, officers are collecting evidence, and in many cases, the report would provide a timeline for when the investigation is predicted to be completed. And in those 12 instances, whenever a timeline was provided, in most cases, timelines were not met. So it was really a very puzzling process, and it just made it very difficult to understand why the investigation was taking so long. And it was against the spirit of SEPA in terms of providing a mechanism for people to be able to take part in the enforcement.
You've mentioned your own process quite a bit today, and I appreciate that. I'm sure there's others that may come forward on how they view this working. But you've mentioned the 2017 SEPA report. And in response to the Standing Committee's report, then Minister McKenna noted that amending the Act to allow citizens to use the courts to enforce the Act may fundamentally alter the way that SEPA is enforced. So do you think that the government's response was incorrect to the previous report?
Well, I think an important thing to realize about how enforcement, and specifically civil enforcement, works in SEPA is that we do have mechanisms in SEPA for civil enforcement, and I mentioned some of those mechanisms, but they're just not working, they're not functional, and they need to be improved. And in terms of whether that would alter the fundamental way that SEPA is informed, I would disagree with that, because I would say in a way it would, improve it and make it better, because civil enforcement usually comes in, to complement government enforcement. So in a case when government is, fails to enforce or is delayed, or the enforcement is not reasonable, then citizens could step in and bring in environmental protection action. And it's important to also note that this is not a criminal proceeding. This is a civil proceeding, and it's something that exists in most federal environmental laws in the U.S. and in Australia, and has worked very well in those jurisdictions.
Great. How much time do I have, Mr. Chair?
About 20 seconds.
Okay. I'd just like to thank the witnesses. Appreciate their interventions today.
Thank you. Passe à Monsieur Baker pour 5 minutes, s'il vous plaît.
Over to Mr. Baker for 5 minutes.
We're calling you that now. I want to thank all the witnesses for being here today. I'm going to start with my questions to Mr. Sharp. And Mr. Sharp, prior to being elected federally, I was a member of the provincial legislature in Ontario and did a lot of work on consumer protection issues. And one of the things that I learned about consumer protection is that if you want to prevent violations of the Consumer Protection Act, things like people who are duping consumers or going door to door and selling things door to door, which is now illegal in Ontario, there's two factors that someone who's about to breach the law considers. One is, what's the likelihood I get caught? And number two is, what's the penalty? What's the penalty if I do get caught? And so I'm wondering if I think about those two categories, and we're thinking about CEPA, if you have any thoughts or advice or in those two categories, like, are there things within CEPA that could be improved to increase the likelihood that violators are caught? And is there anything you would suggest that needs to be done in terms of making sure that we strengthen the penalties for those who do?
Thank you, MP Baker. Excellent question, and absolutely something that we continually have made kind of a tenet of our work at the ICCT. Is it's not good enough just to have strong regulations on the books. You have to have effective compliance and enforcement and penalties so that these companies don't just see fines as the cost of doing business. It has to be a meaningful deterrent for ceasing that behavior. In terms of the specific actions that Canada can do, I think that working with colleagues at the U.S. federal level to strengthen the in-use testing requirements for vehicles. As I mentioned previously, we've offered up several concrete ways in which remote sensing can be mobilized to be able to start to collect lots of data about how vehicles are actually performing in the field, and ways to actually pinpoint and find defeat devices or models that have defeat devices very cost effectively. So we're really excited to have governments start to use that method. But absolutely, penalties have to be stringent, and there has to be a commitment on behalf of the government to pursue those penalties, particularly in cases like these where the actions were just unprecedented in over several years.
And if I can follow up on that, Mr. Sharp, so that's helpful. And so if we step back and not just look at this case, but in general, because CEPA covers a range of harmful and toxic substances. I mean, I guess I'm wondering, like, are we? You talked about in-use testing of vehicles, but CEPA covers a whole range of things, right? I mean, we regulate dry cleaning, for example. So, is there, in terms of that likelihood of getting caught category that I talked about, is there something more we should be doing to increase the likelihood that people who violate CEPA get caught, regardless of the sector, right? Stepping back in general.
Yes, absolutely. I think I can say with confidence that at a very high level, compliance and enforcement should be the bedrock of any regulatory program, whether it's vehicles or dry cleaning, as you mentioned, water quality, across the board. It's not only enough to have that strong regulation in place, but governments have to be verifying that manufacturers and companies are doing what we expect them to do. So trust but verify has been our mantra for us.
Okay. And in terms of the penalties themselves, and again, I'm just stepping back and looking at CEPA in general, right? As it covers all sectors and all potential infractions. Like, what are your thoughts about the penalties in CEPA?
I can't say with specifics as to the penalty levels in CEPA. I don't have that information offhand. But I would just say that at a high level, I think that there just has to be a commitment on behalf of the Canadian government, particularly in this case, to go after Volkswagen in a way that's commensurate with what happened in the US.
Okay. Chair, how much time do I have left?
25 seconds.
Okay, I won't be able to use that time, but I want to thank all the witnesses for being here today. Thank you.
Thank you. Madame Posey.
Oui, alors, oui, merci.
Thank you. I think I'm going to ask Mr. Wright the question. You've talked a lot about what's been done in Canada and the shortcomings. What was in it for Canada by behaving the way it behaved when there were such higher and more severe fines in the U.S.? We had that example. It was staring Canada in the face. So how could we understand what the motivations must have been for Canada to behave as it did? Do you have any idea?
I do not. I can only go by the record and the court record that was made available to me. It is something where the Crown prosecution team should be asked what was going on and why did you agree to a penalty that was significantly less than the one meted out in the United States.
Pistes, explorer des pistes pour
And in terms of attitudes to better understand the motivations, we can't know about it. You were saying that it's the Crown prosecutor who would be able to tell us. My other question would be perhaps addressed to Mr. Malice. We've talked about what's happened in the States. There were the fines, and there was the whole notion of reparations, which I talked about with Mr. Sharp. And there was also an engineer who was sentenced to 40 months in jail. So clearly, the standards are not, our norms are not harmonized with the U.S., but pollution knows no borders. Is there a way to harmonize our standards for this sector?
Thank you for the question. I'm not sure I am prepared to answer that question in terms of harmonization within the specific sector. I'm assuming that's the auto sector, considering that it's not my area of expertise. But perhaps if there's something else that I can answer to with respect to this issue, I'm happy to do that.
Non, je voulais voir dans le...
No, I was really wondering about whether what applies to the U.S. could apply here, but of course I'm talking about vehicles. Thank you. Now over to Ms. Collins.
Thank you, Mr. Chair. I just want to go back to this question that's been raised a few times just about the proportionality of the Canadian fine. Mr. Sharp, in your opening remarks, you mentioned that it works out to about $55,000 per vehicle in the U.S. versus $2,800 per vehicle in Canada. It's much smaller in Canada than the multi-billion-dollar fine paid in the U.S. And so really question both for Mr. Sharp and Mr. Malice, just in terms of, do you think that the Canadian fine is proportional to the scale of the crime committed and its impact on the environment and human health? And really, if you want to take a moment, either of you, if it seems relevant, just what is the impact on the environment and human health, and how was that or wasn't it taken into account in the Canadian plea agreement?
Should I go first, or David, would you like to? Okay, I will.
Sure.
I'll go ahead. I absolutely think that the fine was not proportional to the scale of this crime. As I mentioned, this is one of the worst environmental crimes in the history of Canada. And if we want to just compare to proportionally to the US, we had 128,000 affected vehicles that were rigged and sold and imported here. That was about a fifth of the number of vehicles that were affected in the US. So even though the US has 10 times the number of our population, in terms of the VW cars that were impacted, they were 5 times higher than us. But then if you look at the fines that they levied, it was much higher and greater in proportion than what we did here. And then one thing that I wanted to share, I'm going to look at my notes here because it's some numbers that I jotted down. The way the charges were packaged was really, I think, troubling because, for example, 10,269 model 2011 VW Jettas. All of those, the importation of all of those cars were packaged under one offense. And that basically limits the number or the amount of fine that could be levied for that specific charge.
Thank you.
And I think that was troubling for us to see.
Thank you. We now go to the Conservatives. Is it Mr. Albas again?
Mr. Chair, I'd like to actually share my time with Ms. Collins. I think she's on a roll.
Okay, good. Okay.
Thank you so much, Mr. Albus. So maybe just to allow Mr. Malice to finish what he was saying, and then to Mr. Sharp. Oh, and Mr. Malice, you're just on mute.
I apologize. I was about to finish, and the point that I was going to make at the end was that the way the charges were laid and the packaging of 10,000 cars under one offense, I think it was one of the reasons why we saw the fine per car reduced to about 1,500 compared to the I can't remember the exact number, tens of thousands in the U.S.
Who's next? Who's next?
Sure.
Just to quickly add to that commentary by Mr. Malice, it's my understanding that the per vehicle maximum fine amounts in the U.S. Clean Air Act versus the Canadian Environmental Protection Act are fairly similar in terms of their magnitude. So the fact that, as Mr. Malice pointed out, that so many of the per vehicle charges were bundled together seemed fairly arbitrary and wasn't commensurate with how things played out in both the U.S. as well as California. So that was one of the reasons why the total fine amount, as well as the per vehicle fine amount, was so much less in the Canadian context.
Thank you so much, Mr. Sharp. And just maybe back to Mr. Malice for a moment, just can you speak for 30 seconds about the kind of impacts on human health and to the environment of this case?
Yes, absolutely. So the main pollutant in question here with the VW violations is NOx, or nitrogen oxides. Nitrogen oxides are, known to cause cancer or to, have been linked to some cancer conditions. And Health Canada has data to show that exposure to NOx is actually associated with many deaths in Canada every year. But there are also other pollutants that come out of the diesel exhaust of diesel engines that were not particularly, part of the regulatory charges, but for example, particulate matter. So all of the diesel exhaust together can have severe public health impacts.
Thank you so much. I'm sorry to interrupt. We have limited time, and I just want to check in about Mr. Wright had mentioned this idea of an impact statement, that really there was not enough time to do that. It sounds like the provisions for around public participation, could you elaborate on what was used in this case? And they seem to have fallen short. So what we should be explicitly doing to change, to follow, or to strengthen them. That was to Mr. Malice.
I'm sorry, could you repeat the question? My headset for some reason just disconnected.
For sure, Mr. Chair, I hope that we could give me just another 15 seconds, if that's all right.
Of course.
So really it was around public participation. So Mr. Wright mentioned a kind of victim impact statement. Really there wasn't enough time for people to submit that. So it doesn't seem like these impacts were taken into account adequately. And so what, in your opinion, should we be doing to strengthen the provisions for public participation that seem to have fallen short?
Thanks for the question. So I'll be quick. Compared to the US, where authorities and the Crown invited community impact statements and victim impact statements, we did not see that happening here. And for the process that David was speaking to in terms of the community impact statement in the Canadian proceedings, I was one of the people that tried to submit a community impact statement, and the Crown prosecutor did not allow me to present that, and I won't go over or repeat what David said, but basically we were not able to present that statement. And the problem that we saw was that we, unlike the US, where the prosecutor, saw the communities as sort of an important piece of the prosecution. Here, it was the other way around, where we felt that we were being kind of locked out of the court process, and we weren't able to represent our, communities. And when it comes to presenting an impact statement in terms of how the VW crime impacted public health.
Thank you.
And could I just ask that Mr. Wright's opening statement be sent to the committee as well? And I think we received Mr. Sharp's, just to make sure that we have all of the opening statements and remarks written on prepared speaking notes on the record.
Apparently we've received it, but it's being translated. Is that? Yeah.
Okay, great.
Okay, we'll go to Ms. Sachs for 5 minutes, please.
Thank you, everyone, and thank you to all the witnesses who are here today. This is my first time being on the Environment and Sustainable Development Committee, having recently been elected to the riding of York Centre. And, the environment for my constituents was a significant issue, not just in terms of what's happening currently, but also in how we are preparing ourselves for future generations. And while I am thrilled to be on this committee, my understanding is that today, the focus of the study is really on enforcement and collaborative measures going forward. How do we do better? So my first question with that in mind is first to note it. I noted that it's actually directed to Mr. Wright. I noted that the government has invested $46 million over the next 5 years in terms of environmental enforcement. And I'd like to hear from you, Mr. Wright, about the existing collaborative efforts are between the different levels of government that are currently in place regarding enforcement. And would you be able to explain in more detail, perhaps to me in my home province of Ontario, how those work to ensure enforcement measures are working collaboratively to protect Canadians?
Mr. Wright?
Sorry, the federal government in the federal Crown's office is a completely separate organization from the provincial crowns. It is certainly conceivable that the provincial crowns and the police operating in Ontario could have laid charges against Volkswagen and could have laid criminal charges against them. There's no communication or cooperation in these kinds of investigations between provincial crowns and federal crowns. And it's certainly my view that such collaboration does make some sense in certain specialized prosecutions. The understanding of the criminal process and the understanding of the environmental legislation and the environmental science and collaboration between the two parties could assist the Canadian public and stand for a more formidable enforcement of laws against serious environmental violators.
Thank you for that. So my understanding is that collaborative efforts between the different levels of government to ensure enforcement measures are put in place would be helpful.
Certainly, and I would also suggest that I'm not aware of, but it may be possible, but there may be collaboration between the provincial and federal environmental organizations, but I'm certainly not aware of it.
Okay, thank you. I appreciate your response. My next question is with regards to the Environmental Damages Fund. So we know that the EDF currently is collecting funds from fines, court orders, and other measures that take place. And with the VW court case, the largest damages fine in the history of Canada was levied at $196 million. And my understanding is the aim of the EDF is to fund the projects that restore the environment and conserve wildlife. So my question is now either to Mr. Sharp or Mr. Malas, actually both of you could answer. Would you be able to explain to me a little bit more about the benefits of having a program that's geared to creating environmental benefits and from enforcement measures if the system is replicated, and if the system is replicated in other countries? Do we have a model to work by?
Who's going to answer first?
Yes, thank you, MP Sachs. I do believe that the process by which the funds were earmarked, both in the U.S. As well as in California. California had its own separate legal process that it went through with respect to Volkswagen. But in both cases, we've seen significant amounts of the fines that have been set aside specifically for projects around electrification and also advancing some other emission reduction programs. And this is across the transportation sector, which is really encouraging. So it's not just limited to light duty vehicles. It includes buses, heavy duty trucks, even ships and locomotives in some cases. So the fact that these funds, which are substantial, are given the opportunity to make such an impact across the transportation sector with specific goals towards electrification and also environmental justice. That's been a really key focus as we try and get these cleaner technologies deployed in the communities that are most impacted. So absolutely, I think that Canada has a blueprint that they can follow in terms of what the US and California have done.
Merci. Alors, on est de retour aux conservateurs. Je ne sais pas qui va poser la question.
Yes, we're going to be.
Thank you to the Conservatives. Not sure who's going to ask the question.
Mr. Chair, if we could please pass this over to Mrs. Collins, please, again.
And I want to thank Mr. Albus and the
Ms. Collins, sorry.
And the Conservative Caucus again for giving me time. We heard in Mr. Sharp's statement, or on my understanding, that there are other companies who have used defeat devices, and one of my concerns is that we've been waiting for the government to implement the clean fuel standard, and a key part of it's one of their key parts of their plan to manage pollution. Seems like those kind of standards will only work if companies aren't able to get around them. So first, maybe to Mr. Malice, to your knowledge, are there other companies being investigated or charged in Canada?
We're not aware of other companies that are being investigated or charged, but we are aware of charges that have been laid in other jurisdictions against other companies. Namely, I would mention as an example, Daimler, which owns Mercedes-Benz, and I believe, according to a class action lawsuit that's been filed in Ontario, some of the documents that I looked at claim that there were about 80,000 rigged or affected vehicles that were imported and sold in the Canadian market, but we're not aware of any investigations happening by ECCC with respect to that company or other companies.
And so 80,000 just in Canada. Do we have a sense of how many other cars with defeat devices may still be on the roads kind of around the world, either Mr. Malice or Mr. Sharp?
Maybe I'll let Mr. Sharp answer that question. He might have more information on that than me.
Yeah, I don't have the numbers in front of me. I certainly, there have been significant recall efforts around the world for several, if not all of these companies that have been found to have these defeat devices. We've done some estimates to try and figure out what the impacts are of actually having those vehicles be in compliance. But unfortunately, I don't know offhand how many vehicles that we estimate are still on the road polluting at those levels.
That's okay. And do we have a sense of what are the possible consequences to human health having these vehicles still on the road?
Well, I guess it's somewhat of a good thing that diesels aren't so popular in the North American market, particularly in the U.S. and Canada. We've certainly in Europe, there have been, we estimate, thousands of premature deaths as a result of this whole situation. So we, as an organization, like to remind ourselves that these aren't just numbers that we're throwing around. These are actually people's lives. These are premature deaths. These are hospitalizations. These are asthma cases. So that's why we really think that this is an extremely important issue, and why we're doing and putting so many resources towards trying to empower governments to be able to measure and figure out the extent of the problem and devise policy solutions to
Thank
try and
you.
rectify.
Thanks so much. And just since the beginning of the Volkswagen investigation, to your knowledge, has Canada taken any action to improve its compliance and enforcement operations? And this again to Mr. Sharp or Mr. Malice.
Maybe I'll jump in. I'm not aware of any steps taken by the federal government to improve compliance checks and enforcement. But if I could just add one sort of quick answer to the previous question that you asked of me and Mr. Sharp, the 128,000 vehicles, Volkswagen vehicles that were sold in Canada that were rigged, the emissions from those vehicles is the equivalent of more than 4 million cars. So that, just to put into perspective, the amount of exhaust that excess emissions that were polluting our air, and even though we don't have research to indicate exactly what the public health costs in Canada were, we know that up to 15,000 Canadians die every year because of air pollution. So putting the pieces together can really help to paint a picture of how harmful those excess emissions were.
Thank you. And Mr. Chair, how long do I have?
25 seconds.
Okay. Maybe just Mr. Sharp, you talked about penalties leading to accelerated electrification. What do you see as some key changes Canada should make to, be modeled after some of these going in the good direction of using it for accelerated electrification?
Maybe one key change or two.
One key change.
One key change, a simple one, is to just significantly boost that fine and penalties amount. Really making a significant impact on electrification is going to require a lot more than the roughly $200 million that has been levied so far.
Thank you. Mr. Longfield.
Thanks, Mr. Chair, and thanks to the witnesses. I'm going to turn over to share my time with Raj Saini first of all, and then I'll pick up what might be left at the end of his time.
Thank you very much, Chair, and thank you very much to all the witnesses for testifying today. I really appreciate you taking the time. This question is for Mr. Malice. Mr. Malice, it seems I don't understand some of the numbers that you've expressed, and I have the numbers in front of me. So how many charges were filed in Canada against Volkswagen?
I believe it was around 60 charges.
60 charges. And what would have been the maximum fine total if all those 60 charges had been fined at the max level?
So according to I guess a calculation that one of my colleagues made, and this is something that yeah, like I'm not sure if this is the precise number.
Okay. So
But
the precise number is 265 million. If all 60 charges were fined at the maximum level, it would have been 265. So our fine that we set was at 196 million, right?
Yes.
Okay, so that would have been almost 73% of the total fine amount, right? Okay.
Yes,
So-
but if I can just, I guess, maybe just clarify something.
Yeah.
So the issue around how, the entire number of cars of a certain model were packaged under one charge or one offense is, I think,
No, but-
how the maximum number was reduced. But if we looked at
But no.
each car separately, it would have added up to a much higher amount.
Well, so the maximum fines that could have been applied to Volkswagen with the 60 charges would have been 265 million. I don't disagree with what you're saying. I'm just looking at the gross numbers. Would have been 265 million, and we fined at 196 million, right? So that would have been 73% of the total fine amount. Now in the United States, for the same charges, do you know what the value of the total criminal charges would have been if Volkswagen had been fined to the max? It would have been 32 billion. And the civil penalties would have been between 17 and 34 billion. So they would have had, if they had a maximum fine count, it would have been between 49 to 66 billion. But do you know what they were actually charged?
I'm not very certain.
Okay, so Volkswagen paid 2.8 billion in criminal penalties and 1.45 billion in civil penalties. So totally they paid 4.3 billion out of a maximum, if we look at the lower end, 49 billion. So that would have been 8.6%. So don't you think that in Canada, we had a higher reach in terms of fines as compared to the United States?
I do not think so. And I'm happy to provide some calculations afterwards. I'm just worried that if I try to provide those calculations right now, I'm going
No,
to.
I have the numbers in front of me. These a lot of these numbers are Canadian from Canadian media or American media. So I would suggest that in terms of, and I can appreciate the fact that we can have a discussion where the fine value is not high enough in Canada and it's more severe in the United States, and that's a perfectly legitimate argument. But comparatively, if you look at both countries and you look at both judicial regimes, we charge a higher percentage of the total fine cost as compared to the United States. So I think that, I think in terms of, and I don't know in terms of what the agreement was, but I think that we, as a jurisdiction, were more punitive against Volkswagen than the Americans were. Would you not agree?
I'm afraid I won't be. I disagree with that, and I think much of the analysis by experts has shown that we were far behind.
In terms of packaging all that, that's fine. But I'm just looking at the maximum fine value in Canada that could have been charged under Canadian law as compared to the maximum fine law in the United States. We had a greater penetration of penalties than the Americans did, and also the Australians also, because there are 14 jurisdictions in the world. But anyway, I want to leave some time for my friend, Mr. Longfield.
Mr. Longfield.
Thank you. I have about a minute left. So I'm thinking more in terms of, we're not trying to relitigate a case here. I mean, the courts do what the courts do based on what we give them in terms of regulations. I think we've made the point that the 2017 report needs to have some real consideration. Unfortunately, we haven't been briefed yet by the department, so it's hard to see where they're at in terms of that process, but that'll come in future meetings. In the throne speech, we're looking at investing $46 million over 5 years in additional environmental enforcement to try and give us more resources to be able to handle, especially these serious offenses. The NOx, though, I want to get back to the NOx very briefly. Are we including that in our climate change list of greenhouse gas emissions, or is that something we need to also consider including? To Mohammed, please.
Brief answer, please.
I just wonder if Mr. Sharp might be better positioned to answer that question.
Mr. Sharp, briefly.
My assumption would be that Environment Canada is taking into account NOx as it impacts ozone formation, but I do not know for sure offhand, and I don't want to speculate.
Okay.
That'll be something we want to check on. Thank you very much.
Merci, Monsieur Longfield. Maintenant, Madame Posé.
Thank you, Mr. Longfield. And now over to Madame Posé. Thank you. We have figures here which have been provided, according to which in Germany there were 1,200 early deaths because of these vehicles, which were hidden. I think that when the environment and human health are harmed, when it's intentional and this is only for profit, this should be severely punished. So this is perhaps my preamble to arrive at my next question. The House of Commons referred the examination of the Act to the Environmental Committee. So with Volkswagen, with the shortcomings that occurred, are there any amendments that you could suggest that we introduce to this law? I'm referring more specifically to Part 7, which is control of pollution and waste management, but let's focus on the pollution aspect, pollution monitoring. So who's the question to? Well, whoever would like to answer it. Do I have any volunteers?
If that's okay with the rest of the panel. So three recommendations, very easy recommendations I can highlight right now. They're not within the context of Part 7. They're more within the context of, well, I think they're probably more spread out throughout the Act, but related to enforcement. The first one would be to remove the prerequisite for a citizen to be able to bring an environmental protection action, the prerequisite of investigation, which is what I faced in this issue around Volkswagen. So the fact that the minister has to first launch an investigation and complete the investigation, and then the concerned citizen that wants to bring forward an environmental protection action has to demonstrate that the minister failed to investigate and respond properly. That's a very high threshold and a significant barrier in terms of discouraging people from providing or from bringing forward environmental protection actions. The second one would be to remove the significant harm threshold that, in the case that a citizen was able to pass the first bump when it comes to the investigation, we, as a citizen, we still have to prove that there was significant harm to the environment, and those are, that language is very difficult and could position, any citizen in, to fail basically.
Merci.
And then the third one would be around cost, to ensure that citizens are not paying costs if they are unsuccessful.
Merci. Merci beaucoup. Alors, on passe maintenant à Madame Collins.
Thank you very much. Ms. Collins. You're in mute.
On some of Mr. Saini's comments, to me it seems like he was misunderstanding a bit about what could be a maximum penalty in Canada with this case. So I just wanted to go back to Mr. Malice and, in your opinion, and potentially maybe open up to Mr. Wright if you have a comment on this, what, even if you want to ballpark and then send us some documents afterwards, what could have been the maximum charge if these they hadn't bundled them, if they hadn't, if it hadn't had the shortcomings it did.
The number of charges is completely discretionary. So they chose 60 charges. They could have chosen 100 charges. They could have chosen 200 charges. They could have chosen 128,000 charges if they wanted to, but that's completely unreasonable. So the figure is actually it's a bit of a chimera. It's the maximum figure and the minimum figure for fines. It doesn't really assist you very much. What happened, it looks like, is that there was a meeting between counsel, the Crown and the defense before charges were laid. So the whole determination as to how many charges would be the subject of the plea appeared, one inference is that it was the object of negotiation between the prosecution and the defense in a very, very unusual circumstance. So the fact is, the amount of money and how punitive it is could have been determined by was determined by the Crown, who had a wide open field. They could have gone as high as they wanted to and as far as they wanted to. And just as in my materials, I end up by looking at just the figure for fines and not the civil remedies. So certainly from what I look at, what I understood is that it was $4,745 per vehicle in fines, not civil remedies in 2017. And in Canada, it was $1,535 per vehicle. So it's less than 1/3 of the gravity of the fine. So those are the comments I have.
Merci.
Thank you, Mr.
Le temps est écoulé, mais on retourne.
Thank you. Your time is up. And now back to the Conservatives. Again, I don't know who's going to actually do the questioning. Is it Ms. Collins?
On a roll here.
OK, d'accord,
I'd
je
like to see
comprends.
one more round here.
Alors,
Okay.
terminé.
Thank you. So I just wanted,
Ms. Collins, you hadn't finished.
so I just wanted to turn it over to Mr. Malice and ask, just in response, you had mentioned there was some estimates of what, if the charges hadn't been bundled in the way they were, what the approximate ballpark of the fines would have been here in Canada. And then if you could follow up with written material with those numbers.
Yes, I'd be glad to follow up with some materials. And it was my mistake to come, I guess, unprepared with one number that I probably didn't put in my notes. So I think, as Mr. Wright explained, the way the Crown would have played the charges would have played a big role in determining what the maximum fine is. But if we consider each car as an offense, I think the maximum fine under SEPA would have been, several thousand to maybe a couple, probably, I can't remember the number, but even if we assume it was several thousand, and then if you take that number and multiply it, by the number of cars that were imported, and if the charges also included the sale of the cars, and also, some of the other charges that were laid in other jurisdictions that were not laid here in Canada, that would have added up to be much, much greater than what we find the company. But I would be glad to follow up with exact numbers.
Thank you so much. And I just want to jump back to a topic that was mentioned before about the fact that Environment Canada is doing less inspections, less prosecutions. And Mr. Malice, you had mentioned that 20% of investigations were dry cleaners, but the report that you had referenced, the fall 2018 report, also found that 70%, so 70% of prosecutions, the vast majority, were of dry cleaners. And yeah, just wondering if these numbers concern you, and in kind of addition, you had mentioned there's more resources needed. If there are any other steps that we could be taking to make sure that it's not small mom and pop shops and it's really these larger companies who are doing the biggest lion's share of pollution.
Thanks for the question. Yeah, when it comes to that percentage, 70% of all convictions in, I think, a couple of fiscal years, between 2014 to 2017, I think they were all targeted dry cleaners. It raises a question to me about whether ECCC is, capable and willing to take on large polluters. The case of VW, I think, is a prime example. And yes, most certainly there's a funding issue, a resourcing issue. So I think one thing that would be very interesting for this committee to look into is the capacity within ECCC enforcement. So I believe 201 enforcement officers in 2018 were responsible for implementing not only the SEPA regulations, but also the Fisheries Act regulations across, our massive country. That's not an adequate number, but I'm not sure what the right, number would be. And I think that's something that's worthwhile exploring. And then, considering the fact that ECCC is focused on, very few substances in its inspection measures and enforcement actions, and focused on small, mom and pop shops, I think it's troubling, and it would be interesting to explore in the study by the committee why that is and what resources Environment and Climate Change Canada could have to be able to take on, large scale crimes.
Do I have, Mr. Chair?
1 minute.
Okay, maybe just to give Mr. Sharp another opportunity. I know you mentioned the one thing, which is that bigger fines would help with leading us in the direction of accelerated electrification through this process. Are there other steps that you think that Canada should be taking to ensure that this money is helping us move towards zero emission vehicles and move towards our climate targets?
Yeah, I can't say specifically how SEPA is set up with regards to how fines and those monies can be earmarked, but thinking about modernization of the SEPA Act, we certainly, as an organization, would be very supportive of being very intentional, particularly with regards to how fines that are levied from the vehicle, the auto sector, are mobilized in terms of supporting not only environmental protection, electric vehicles, but also in terms of industrial policy. As I previously mentioned, really mobilizing electric vehicle production across the supply chain in Canada, we think is really critical for the success of the Canadian auto industry.
Thank you. I have next on the list, I have Mr. Saini, but Mr. Saini spoke before. Is it still Mr. Saini or is it Mr. Longfield? Or?
I'll take some time, and if any of my colleagues want to jump in, that's fine. They can just let me know. The one question I have for you, Mr. Sharp, is I read one of your blog posts where you said 2 feds are better than 1. And I found that very interesting because if you look at the alignment of the North American auto market, especially between Canada and the United States, about 98% of the vehicles are sold similarly. And you wrote that how important it was that if one jurisdiction did some of the work in terms of enforcement, that the second jurisdiction didn't necessarily have to do the work or didn't necessarily have to commit that much because one jurisdiction had already done the work. How can we improve that in terms of our own legislation here in Canada?
Yeah, so thank you for referencing that blog post. I think the main message from that piece was to emphasize the fact that Canada and the U.S. are certainly integral partners in terms of vehicle and fuel policy. But I do want to make the distinction in terms of how penalties are being assessed. And we certainly think it's the case that it's not just enough that Volkswagen was penalized in the US, and that's good enough for the entire world. We really think that each individual country and jurisdiction has the right to assess for itself what the damages were from those actions and to levy penalties accordingly.
No, I thank you for that, Mr. Sharp, because I've read somewhere that Volkswagen is also in charge in 50 other jurisdictions around the world. Now, my final question to Mr. Malice is, I'm sure you're aware of the Environment Damages Fund, and I just wanted to, because a part of the settlement is going to that fund. I was just wondering, is there any way you think we can improve it?
I think one way that it could improve, and I haven't looked into this in depth, would be to ensure that damages that are being or fines that are being collected related to a specific type of damage. So kind of looking at the model in the US where, for example, the 196 million that were collected from EW, is that money going into preventing that kind of pollution that VW caused? Is it going to ensuring reparations or addressing the kind of pollutions and impacts that certain communities faced from that particular violation or offense? So kind of specifically when it comes to these fines that are really massive, like 196 million, making sure that that money is going towards moving forward solutions in a significant way, like the electrification issue that Mr. Sharp raised.
Okay, great. Thank you very much. I'll pass over my time now to MP Longfield.
Great, thank you. And just for Mr. Sharp, I wanted to continue on the thought about the types of chemicals that are damaging to human health and animal health and plant health for that matter. When we're looking at the broader impacts through SEPA on I also chair the All-Party Health Research Caucus. We just had presentations from researchers on pollen counts, on particle counts from forest fires, and you're mentioning NOx. I want to just unpack that a little bit, whether your organization is looking at all types of pollution and the health effects coming from each, and whether they should be included in the SEPA.
Yes, absolutely. We, as an organization, take a multi-pollutant view of vehicle exhaust. Certainly it's much more of a story beyond just nitrogen oxides. That includes particulate matter, it includes toxics, it includes road wear from tires. So really having a comprehensive view of vehicle exhaust, we think, is critical. And in terms of assessing health impacts, we look at as much as we can across that pollutant profile.
And this gives us a good case study from which to base further studies. And we're hoping to see the SEPA review come once it's being tabled in the House, which hopefully will be in the next little while. And hopefully we don't run out of parliamentary time to have you back to unpack that a little bit more. So just want to thank you for your contribution to today's discussion, and turn back over to the chair. Unless you have another comment, or we have a few seconds.
Il vous reste 25 secondes si vous avez de quoi ajouter.
You have 25 seconds left. If you have anything to add, please go ahead.
C'est pas nécessaire non plus.
But you don't have to. It's not compulsory.
25 seconds. The mandate of this committee isn't to get into the legalities, but really to look at the policy impact. And I think we've had a very good discussion around that this afternoon. So
effectivement, j'aimerais remercier.
Yes, and I'd like to thank the witnesses for making available to us their high level of expertise. I think we've learned a lot this afternoon, and I think that it's a very good beginning of our study. I'd also like to thank the analysts, because the analysts put together a very stimulating panel in a very, very tight time frame. So thank you, analysts. You really put together something very good. As I've already mentioned at the beginning of the meeting, I wanted to set aside 15 minutes at the end of the session to discuss the third report of the steering committee. So I would move that we move into in camera now, since we're talking about the content of a report which is confidential. So if there are no objections, we will move into in camera now. So what that means is that we will disconnect and then reconnect with a different code which you will be sent. It'll take about 5 minutes to do all of this. So thank you again to our witnesses.
Mr. Albus? Yeah.
No, please finish. I just want to come back to the in-camera motion.
Sure. Well, I'm done. I see Mr. Baker's hand up, I think. Yeah.
Oui, Monsieur le Président, est-ce que les codes pour la...
Yes, Chair. Have the codes for the confidential session already been sent? Apparently, yes, because I haven't received any. We'll look into that. Mr. Albus?
Yes, I didn't want to interrupt you thanking the witnesses because we do appreciate their participation today. What I would like to do, Mr. Chair, though, is that it shouldn't be up to you to be the super motion, and chair. So what I'm going to suggest is that I move to go in camera for the next.
I appreciate that very much because it was becoming a big burden on me to do both. And I appreciate you. I appreciate you bringing that up, Mr. Albus. I'm just getting used to the procedures of committee. Pardon. Yeah.
Check
So
our inboxes. The emails are there now.
what's that? Oh, you got it? Okay, great.
Check
So
the
we'll disconnect. We'll reconnect. Thank you again to the witnesses and to the members for your great questions. Thank you.
Thank you.